Coming up on today's edition of Women and Money, the shit we don't talk about, our guest is Marilyn Chinitz, a divorce attorney in New York.
Prenups, she tells us, is not just for the wealthy.
And there are many things that should be in a prenup but are often overlooked. I wonder what those are.
Well, let's jump in and talk about how regular people like us can go about creating a prenup.
Gloria Steinem once said, "We will never solve the feminization of power until we solve the masculinity of wealth." Barbara Provost and Maggie Nielsen are the team at Purse Strings that will help you navigate the ins and outs of financial independence so that you can be financially fearless. This is Women and Money, the shit we don't talk about.
Hi, Marilyn. Welcome to the podcast.
Thank you. Good morning.
Of course. When you told us you were an expert on prenups, we knew we needed to pick your brain. But first, can you share a little bit about yourself before we jump in?
Sure. Without divulging my age, I will tell you that I'm practicing law for 41 years. And my specialty was first corporate litigation, and then I moved into matrimonial law many, many years ago. And so I've been practicing as a partner at Blank Grow. That's my area of specialty. And of course, I love it. I've had some very exciting clients. I've represented Tom Cruise in his divorce and Michael Douglas in a litigation, Wendy Williams, private equity, individual hedge fund managers. So I've had a very robust, wonderful clientele. So I'm still doing it because I obviously love it.
Well, it's so important to have that passion in your work, and we're so glad to have you on today with us. We have so many questions. So to dive in, let's start with prenups. What exactly are we talking about here for people who aren't, as sure what prenups are?
Right. So, they're not sexy and they're not romantic, but they are important. They're contracts between couples who plan to get married. And there are a lot of advantages to it, even though people kind of cringe when they hear prenup. You want me to sign a contract? Don't you love me? Don't you trust me? And the answer is yes. But what a prenup does, it saves you from potentially years of litigation if you set forth what your intentions are today. So people have different motivations for a prenup. A young couple, you say, well, they don't really have anything. Why should they have a prenup? But sometimes these young couples are going to be the beneficiary of inheritances or trust distributions or gifts that are going to be in the millions of dollars. And their families generally want to make sure that that money, which is generational money, is protected. So the first thing that an agreement will do is define what's going to be separate property, what's going to be marital property. And that's what a young family, young couple will want to know, and certainly an older couple who has, where the spouses have been married more than one time. And they want to protect their children from their prior marriages. So if we take a young couple, they will look at a prenup obviously very differently. So I just did a prenup recently where the woman was marrying a very, very wealthy gentleman, not wealth that he earned, but family wealth. And that family wanted to make sure that that money was going to be protected and that the appreciation of that money will be protected. So they drafted an agreement where she is to waive any and all interest in his businesses, in his trusts, all the things that his family created. But here's the problem. What you say today and how life takes you down that stream is going to be very different, because what happens is people forget about things. Oh, I got a distribution. Well, that came from my family. That's really separate property. But I want to buy something for us, a house. So let me take that distribution and let's put it into a joint account so we can buy our first home. So what went wrong? You took what was a separate property asset and now you transmuted it into a potential marital asset. But a good lawyer is going to know how to protect what people will do during their marriage life. And what they do is you put in a clause in a prenup that's we call a separate property origination credit. So if that gentleman took $100,000 out of his distribution, separate property, put it into a joint account, put it into a home that he titled jointly, well, now you're really transmuting. But the agreement that his lawyer drafted said that if he can trace it back to his separate property distribution, in the event of a divorce, if that property is deemed to be a marital asset, he gets back his separate property and he gets an origination credit.
Got it.
So it's really important for someone who is embarking on this process of hiring a lawyer to do a prenup, to hire a lawyer who knows about the law. So a lot of clients will go to their family attorney who's never really practiced matrimonial law. They've done a little bit of everything. But by not hiring a matrimonial attorney who knows the law, who knows how judges think, who know the cases, you're opening yourself up to potential problems because you didn't know about that particular case that said you can get a separate property origination credit. So, and then if you take a young couple, what's the advantage of having a prenup?
Right.
Well, how many times do we see young couples, they live a big life, they go to St. Bart's for vacation, he's driving a Porsche, they rented an apartment for $20,000 a month, and then all of a sudden when they're talking about a prenup, you have to make financial disclosure.
Yeah.
So now you've got to submit your financial statement of net worth. And all of a sudden you look and you go, wow, I didn't know you had $300,000 in debt.
Wow.
I didn't know that you're borrowing money for this apartment. And all of a sudden you're getting a full understanding of the financial picture. Now, that doesn't mean you're not going to marry the person. It means that you're going to protect yourself. I don't want to be part of your debt. That's your obligation. It's not going to be mine. So there's an advantage to knowledge, right? And your audience always wants to know, be in the know.
Yeah.
So to me, that element of financial disclosure is very important. And when people are dating and there's no prenup, you're not going to say, can I see your balance sheet, please? If you do, it's kind of offensive. And then he says, well, you're really not marrying me for me. You're marrying me for my money, it seems. So it gives us an opportunity to understand what the financial picture is.
Marilyn, I have a question about that. First, I love that part of a prenup is that you kind of have to expose your financial status, because I don't think oftentimes people do that. And then they get into a marriage and they realize, wow, I didn't realize you had $100,000 in student loans or whatever it was or whatever it is. So that's interesting. The other thing, what you mentioned previously, is once you get a prenup, do you need to change that prenup along the way as you're married and things change, or can you just do once and done?
That's a wonderful question. And the answer is a smart person, smart woman, let's talk about women, should meet with their attorney who drafted the prenup every year.
Wow.
And I do that with several clients who will reach out and say, can we go over the prenup because a lot has changed and we're very happily married, and that's the time to make an amendment. So let me pause for a moment and give you an example. A couple gets married, and at the time of the marriage, he's very wealthy. He's worth $100 million. And he signs a prenup that appears to be very generous. It gives her, in the event of a divorce, a $10 million distribution outright. $10 million is a lot of money if you're a young couple, and it sounds like it's favorable. But now they're married, they have children, and it's 2 decades later. And his wealth went up from $100 million to $300 million. She never looked at the prenup after it was signed. He did, because the prenup said, we call it a title prenup, that it's governed by who has title to a property. Every home that they bought, and there were many, were always titled in his name. So he knew that that would remain his separate property. Every account was titled in his name, so he knew that was going to be his separate property. But she was running the household. She was raising the kids. She was supporting him in his business. She decorated the homes. She designed the homes. But guess what? Years later, she still gets, in the event of a divorce, $10 million. She never looked at the agreement before.
Mm.
And so now that individual comes and says, well, it's unfair. It's unfair that he went up from 100 million to 300 million. I went nowhere. In fact, I probably went down. Between inflation and everything else, it's unfair. And then you want to ask the following questions. We know the agreement was in writing. We know that at the time you entered into the agreement, it was voluntary. You shared that with me. No one coerced you. You thought 10 million was a lot of money. He did put a financial statement of net worth, so he made full disclosure, and he told you that he was worth at that time 100 million. You both had excellent counsel, and there was consideration. For a judge who earns $175,000 a year, if that, 10 million is a lot of money.
Right.
So you can't move to set aside that agreement. So even though he went up in net worth and you didn't, that agreement is the agreement that the court's going to uphold.
And it doesn't supersede state law. I mean, it's
no
in place.
State, so courts, no matter really what state you're in, there's a public policy to enforce an agreement that you entered into, as long as all the things that I just mentioned, you can check off the list. And if you can check that off the list, then the court says everybody can make a private agreement, even a bad one. So the answer is, to your question, which was a very astute and good question, what do? You have to pull out that agreement. And if you want to make changes, the time to make changes is when you're a happily married person. Mm-hmm. It's not when you're getting a divorce. Right. So what did that person, fail to do? She failed to take a moment to take care of herself, right? She took care of everybody else. She took care of the homes. She took care of the children. She took care of his business, of his social life. But she never looked at her own bank account. And that prenup was essentially her bank account. She didn't earn interest. She didn't earn dividends on it. And that, to me, is a very unfortunate situation. So I do tell every single client, I'm going to take you for lunch. You call me. Usually I speak to my clients after their case is done because I remain in contact with them. But I say to them, we're going to have a lunch date a year from now, and we're going to go over that prenup, and we're going to go over what changes happen during the past year, 2 or 10 or whatever it is. And I can tell you that there are a lot of smart women out there who do that. And then we do a postnup, or we do an amendment, or they just simply tell their spouse, I'm insisting that you put that home in joint names. And if it's a happy marriage, happy wife, happy life, they'll do it.
Yeah. Awesome. Well, before we move on to postnups, which we do want to jump into, tell us what we can learn from all of these celebrity couples when it comes to prenup. Because I know you were saying there are some things that are missed in the prenup. So give us the dirty, what's going on.
Well, I think everybody who has wealth wants to protect that wealth. And if you look at it, if it's wealth that was earned before you got married, under the law protects that wealth. What it doesn't protect is the appreciation of that wealth. So if Kevin Costner, who went through a very unpleasant divorce, and he had a prenup, the problem in that case was his wife cherry-picked what provisions in the prenup she wanted and what provision she felt was unfair. So there was a provision in that prenup that stated along the lines of, and I'm not quoting anything, that any residences that he owned before marriage will remain his separate property, and that the spouse will have to vacate that property within whatever the designated time, 90 days or 6 months or a year, whatever it is. And she didn't want to leave because she was there with her children, and she said, I don't want to leave. And ultimately, the court had to intervene. But she chose another provision when she thought that it was unfavorable to him and favorable to her, and tried to assert that in court. And you can't cherry pick provisions in an agreement. It's either unfair and should be, deemed unconscionable and you want to set it aside, or you're bound by it. I think what people do very often is they forget about, and we talked about this earlier, they forget about the terms of the agreement. And people who have a lot of wealth or certain assets, that whether it's books or movies, publishing rights, all of that intellectual property also has to be addressed. If you go into the case of Michael Douglas, when Deandra Douglas wanted a piece of the second Wall Street film, she then said, well, I was entitled under the underlying prenup to the first Wall Street. So if it's a sequel, I'm entitled to it. You have very specific areas that you have to have intelligence on. And so a good lawyer is going to know what areas, if you're representing celebrities, if you're representing athletes, where you want to focus your attention on a prenup. Very often, if you're representing an athlete, for example, they may make a lot of money now. But when they're no longer able to run on the courts like they did or hit a baseball, they're not making that kind of money later on. And so a lawyer who's representing an athlete, for example, in a prenup, has to consider all of those things. And so everything has its own unique set of characteristics. And a good lawyer, and I'm emphasizing that over and over again, someone who has experience knows, the red flag goes off and the light goes on, and you say, okay, well, under these circumstances, this is what you have to do. I think it's also important for your audience to understand, as good as a lawyer is, we're not everything. And I like my clients looking for great professionals to bring in. I don't have a proprietary ownership on genius, brilliance, and intellect. I like to bring in everybody. So if it's trust and estate, I like to bring in that trust and estate partner and say, well, what about this? Because a prenup is not only about divorce, it's also estate planning. I also like a client to meet with their financial advisor and say, come into the fold. Let's talk about what they have, what their needs may be in the future. And so I like that kind of knowledge. And so when I'm working on a case, whether it's a prenup, a postnup, or a divorce, I like working with really good professionals. It's important. You want to make sure your client is fully covered. And let's talk about taxes, right? Let's talk about whether or not a client gets a home or a stock securities account, right? But here's what they don't know. What's the tax that's embedded in those assets? If I say there's a $10 million home, I'm willing to give you that home. And I then say, well, what's the debt on that home? Oh, it's $9 million. Well, then the equity is only $1 million.
Right.
And you're giving me a stock account and there's no tax that's embedded there and it's worth $10 million. So
there's no maintenance.
I think, well, good point. The point is you need to dig deep. All right. Very important. Don't take things for face value. You've got to understand what are the tax implications. If I get a house and I sell that house ultimately, and there's a big gain, do I pay that gain if I'm getting it? Or at the time of the agreement, the divorce, do I say, well, any gain up until this point, we share equally. And if there's gain thereafter, that will be my responsibility. Creativity is super important. And you only become creative if you know the law and you're knowledgeable about all the details.
So Marilyn, when you're setting up a prenup, does the woman need her own attorney and the man need his own attorney?
Absolutely. And so
Okay,
the
so
trusts are very different. And I'm going
okay.
to segue into another area, but a parallel area, which is trust. A lot of people say, well, do I need a prenup if I've already established trust and put assets into the trust? Isn't that protected? And the answer is it protects certain things, but it doesn't protect everything. So if you're negotiating a prenup or a postnup or getting a divorce, you each must have your own attorneys because your interests are not aligned. You don't share the same interest. You're trying to protect yourself. He's trying to protect himself. And to the extent that you can come together and reach an accord, great, but you must have your own counsel. When people are looking at trust as a married couple, they say, oh, let's do estate planning. That's so important. Let's take that asset that's now worth $5 million or $2 million or $1 million. Let's put it in a trust for the benefit of our children. Who doesn't want to do that for the benefit of their kids? And it grows tax-free. And they don't have individual attorneys. They're represented by one trust and estate attorney. Well, here's what happens. Every time a spouse says, let's take this asset and put it into a trust, you've now just taken out a marital asset and put it into a separate entity in which you have no interest whatsoever. And so another red flag, warning sign. If you've entered into an agreement and a marital asset exists and your spouse says, let's take that marital asset and move it into the kids' names. I want them to have it. They get it. It's going to be, we control it. It's ours until we die. Then it goes to them. That's the theme. That's not the case. And if a trust is going to be upheld, you relinquish control. That's the whole purpose. You don't have control over that asset. So it's like saying, I'm taking this business and it's no longer going to be a marital asset. I'm putting it into a trust. It's going to grow, appreciate in value, tax-free, and then it goes to our kids. Well, now it's like going to a company. Now it's like going to Dr. Barb. Now it's like going to Maggie. I no longer have an interest in it. And what you did is just diminished your marital estate. So let's go back to the question, the difference, am I fully protected with the trust? Well, here's what a trust doesn't protect. It doesn't protect the appreciation if money gets distributed out and you put it into an account and that, even in your own name, and that grows in value during the marriage, the appreciation, if there's no prenup, can be a marital appreciation. It also doesn't protect you because it doesn't deal with support. And Maggie, you raised that a little while ago. If you set up a trust, it doesn't deal with the issue of support. What happens if we get divorced? And I'm a believer, don't waive your rights to maintenance. What you can do is you can kick the can down the road. So the agreement can say, and I'm kind of segueing in and out, the agreement, the prenup can say, we're not waiving maintenance. There's no waiver of maintenance, but we're not defining what maintenance is because if a young couple, they don't know what they're going to make in the future. We don't know who's going to stay at home taking the kids and who's going to go to work. So we said, mostly in the agreements, no waiver of maintenance. If there's a triggering event, that is, somebody wants a divorce, then we will determine at that time what maintenance, if any, should be agreed upon. And if we can't agree, we'll go to the court. Now, you can't put in certain protective measures by saying things like, I'm not waiving maintenance. However, the duration should be half of the length of the marriage or a third of the length of the marriage. So that if you're representing a husband, you can at least shrink the duration. You can lower it. You can make it as, half, a third, whatever you want, but at least you have some control over it. If you waive maintenance, unless it's super unconscionable and you get nothing else under the agreement, the court's going to uphold that waiver.
Purse Strings offers an available for hire network of vetted professionals who specialize in serving women. When you have a life event that has suddenly made money a priority, you can now move forward with a whole new confidence that you're getting advice and services from savvy professionals who are uniquely equipped to serve your needs. Go to pursestrings.co and use our directory of handpicked financial professionals when you're ready to plan for retirement, navigate divorce, buy your next home, fire up your new business, and more. Go to pursestrings.co or check the link in the show notes. Now you can be financially fearless.
So it seems like, the maintenance is and saying that you're going to have it or we're going to decide it later, whatever it may be, is like an interesting kind of term that you put into the prenup. And so are there other different terms that you think are really interesting that people should include, or maybe the most obscure one you've also seen included?
Well, I'll tell you funny provisions that I've seen in a prenup. But the kind of things that you want to see in a prenup are the following. What we talked about earlier, which is defining assets. Are they separate property? Are they marital property? If I use my separate property, can I get a separate property origination credit back? If my separate property appreciates in value, you're waiving your rights. Or maybe you're not. You see that kind of definition. You see issues concerning support. What happens if there's a triggering event? You also can define how you're going to divide assets. It doesn't mean it's going to be 50-50. Let's say I bought a house, but I pay the mortgage, I pay the expenses, I've paid the capital improvements, I've made the renovations. You didn't put in one penny. I may say, then that house, although it will be a marital asset, if we get a divorce, it's going to be allocated 70% to me, 30% to you. So you can make those refined definitions in the agreement. And you can, protect the spouse against the other person's debt, which is what we talked about earlier. So you can throw in whatever you want. You can craft the agreement based upon your individual facts. I had the funniest prenup that I was presented with, and I've never seen anything like it, but there was a provision that said, you will give me a foot massage once a week for no less than 2 hours. Now, I thought it was a joke. I thought it was a joke. It's not going to be enforceable. And I called the lawyer and I said, that is very funny. I have never seen that. He said, it's not funny. That's been the way they've conducted themselves. And I said, okay, I'm more interested in the finances. I'm not interested in a foot fetish. But I just thought it was hilarious. But essentially, people can craft their own private agreement. And again, as long as it's not unconscionable. And what defines unconscionable? Because I think that's really important. It has to be shocking to the conscience. It has to be something that you go, oh my God, how could you do that to that person? So I represented a woman named Liba Icon against her husband, Carl Icon. And he obviously, as everybody knows, is a billionaire. And at the time of their marriage, he wasn't a billionaire, but he was very wealthy. And their agreement provided that she got a certain amount of money, not an extraordinary amount, maybe $5 million, against his huge balance sheet. And they had 2 children. And this is going back quite some time. The law has evolved, and I'll tell you how in a minute. But at the time of the divorce, she had 3 lawyers. Her first lawyer brought the divorce action in Westchester County, which is part of New York State, but we call it the second department, different than New York County, which is the first department. In the second department, at that time, there was a statute of limitation. So you could only bring an action to set aside an agreement within 6 years of signing that agreement. So she brought the action later than 6 years because they were happily married before then. And the court, lower court, threw out her case and said, you're barred by the statute of limitations. Who goes, oh, you know what, honey, it's 6 years. I need a divorce now, or you got to. Nobody.
Right.
Had that lawyer researched other cases in the same state, New York County, First Department, New York City, there was a judge, Phyllis Gangale Jacob, and she was smart. And she said, wait a minute, you can't throw out an agreement when people are married, if they're happily married and they pass the 6 year. So we're going to toll the statute. We're going to freeze the statute. The statute only starts to run when you are moving for divorce. And so consequently, that first mistake by that lawyer, moving to set aside a prenup in a court that adhered to a 6 year statute of limitation, meant that she was going to lose. Yeah. Her husband went up to the appellate division. The appellate division upheld the lower court. And then there were decisions. Well, she said, it's unconscionable. I'm only walking away with $5 million and use of a house. And the judge said, I'm sorry. I read in the papers that he gifted you a emerald diamond necklace worth $1.5 million plus everything else. That's not unconscionable. Ma'am, I earn $120,000 a year. That's pretty generous in my world. Well, number one, you don't want to hear about what the judge earns because that's not his life. But the point is, it has to be shocking to the conscience. So there was a case in New York where the court found that it was shocking to the conscience. And it was a case called Petracca, Petracca, if anybody wants to look it up, where the court set aside a postnup, and another case called CS versus LS, where the court set aside a prenup. Every agreement has to have consideration. Every single one. I give you something, I get something. In this case, CS versus LS, they entered into a prenuptial agreement, and he was quite wealthy, and she wasn't. And the agreement provided that she keeps all of the gifts that he gave her during the marriage, but she waives her rights to everything else in the marital pool.
Wow.
And, well, you would think, but he did give her nice gifts, right? But not enough. And when she went to court and said, this is an unconscionable agreement, because if, Judge, you enforce this agreement, I walk away with nothing. And these were assets that were all acquired during the marriage. So here's your Birkin bag back. And here's that fake diamond ring that you gave me that's really glass. I want my share of the marital assets. And the court agreed. They said that is shocking to the conscience. Another case in New York where the wife had miscarried. They were married. They had acquired marital assets. She miscarried. And she was feeling very, very down and very depressed. And he took advantage of that. And he said, I want a postnup. If you want to stay married, I'm really not happy. You lost this baby. You lost this baby. And I want a postnup. And you're going to waive your rights to this, this, and this because I put in all the money. And she signed that agreement. Well, when they got divorced, the court said, oh, no, 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 no. You put not only duress and coercion, what you did was horrific and it was unconscionable. And we're setting aside those agreements. But going back to other cases, courts will uphold the agreement. It's a matter of public policy to enforce those agreements that people enter into, but they've got to be fair. They've got to be reasonable, and they can't be unconscionable. And I will tell a client who has the money, give more, don't give less. Show that this agreement is fair, reasonable, not unconscionable, nobody was coerced, it's not a product of fraud, give more. And those are the agreements that are always upheld.
So it really does seem like you need those, someone to sit down with you, really read everything through, whether that be your attorney and your financial professional and maybe your tax professional, but then keep revisiting this as hopefully we gain more wealth or we gain more property or whatever it may be. But also when you have kids, that adds, a different element that 5 million is not going to be enough if I'm raising 5 children. So whatever it may be, it needs to keep coming back to it and updating it. Because we want to stay covered throughout the whole lifetime, even though you do
and
feel
that's
like
when you
you're in
make
a
the
happy
changes,
marriage.
when you're in a happy marriage.
I'm just wondering, what about those of us who don't have tens of millions and billions of dollars?
That's me.
What about, that's me. What goes into just a regular, now that people are either married or a couple's getting married, they don't think they're going to be coming into a lot of money. What suggestions, like, is there a benchmark in which you're like, everyone should have it at this point?
So, there are states in New York that are not necessarily enforcing the agreements. They're not being bound by them. They're being influenced, but not bound necessarily. And I want to address another important point, which is portability. If I entered into an agreement in New York, but then I moved to California, that has totally different laws. New York is a law of equitable distribution. What does equitable distribution mean? Whatever a judge thinks in a particular courtroom on a particular day at a particular time.
Yeah.
That's very subjective. California's community property is 50-50. So again, when you are entering into a prenup, you don't always know that you're going to move. But sometimes people say, you know what, my family lives in California or my family lives in Oregon and there is a possibility. I always like to get counsel in the different state who looks at the agreement. I just had that. I have a client who's getting married, got divorced, getting remarried, and living in New York. And then because of the tax laws, decided to move to Florida. Well, now we've changed the agreement. But what if he moves back to New York? So we want to make sure that there's a portability factor, that what your intent was is enforceable in a different state. I think for young couples, you want to build a marital estate together. Let's face it, you're starting out, you don't have money, you're working hard, you want to create a marital estate, you want to create a marital partnership. However, if my parents gifted me $25,000 or $50,000 or $100,000, I want to protect that. You know why? Because you didn't earn it. I didn't even earn it. Mm-hmm. So the law protects that. So I want to make sure I have an agreement, a simple one. It doesn't have to be an elaborate agreement. I'm just going to deal with what I have currently, what I inherit, and what's gifted. Everything else, I believe it should be marital. And a lot of young couples are willing to do those agreements. They're not offensive. They just deal with what the law would otherwise provide for them. And so when it gets complicated and tax issues get, addressed and trust issues get addressed, they become far more sophisticated, but that usually trends with far more money at stake. And so I think that no matter what kind of agreement that you're going to enter into, it still has to have those check boxes, no matter what.
And then one of the last questions I want to know here is, I know it always varies, but if you're just an average couple, how long does the process of a prenup usually take? And then how much does that typically cost?
So that's
or,
another
a range
good
of that
question.
pricing?
And it's depending upon the complexity of the agreement. It depends upon how much trust and estate matters are being brought into that agreement. Unfortunately, they tend to get negotiated with a lot of adversity, unfortunately. And we as lawyers really try not to do that because the whole point is they're getting married. We want them to enjoy this very special time in their lives and get this behind them. Where a lot of the difficulty comes in is when families come in, when the parents come in, when the grandparents come in. And again, it's that generational wealth issue that they want to make sure that that's fully protected. It's not the young couple themselves. It's everybody else that's involved. A prenup agreement, you want to get it done as quickly as possible, as thoroughly as possible. I tell clients, don't come to me 2 weeks before you're getting married because I don't want to do your prenup. Come to me 3-4 months before you're getting married or 6 months before you're getting married, because remember, you have to do the disclosures and you want to make sure that you've covered all the various areas, and you don't want to leave things in the last minute. You don't want somebody to say, I got a gun to my head. He presented it to me at the last minute. You want to make sure, and there's an intensity to getting it done, because things that linger kind of deteriorate, and that's not the objective. And again, they can be costly. They can be a few, $1,000. They can be $10,000, $20,000, $30,000. And depending upon how heavily negotiated and what's at stake, the numbers get higher. But a good moral lawyer wants to make sure that it's cost effective and it doesn't spiral out of control. And you keep communication open. It's not the time to be adversarial. It's a time to figure out solutions. And that's when I like to have my colleague, my counterpart, creative, so that we come up with solutions rather than, that's it, this is my way or the highway. How else can we address it so that we accomplish what we want for both parties? That's the key in those kind of agreements.
And I will say that, there's this large transference of wealth that's coming into the hands of women to the tune of $30 trillion transferring to women by, the year 2030. So over the next 6 years. So it's interesting to be having this conversation now, because as women do come into some money, we want to make sure they know how to best manage it, how to best protect it, and how to set themselves up for a great financial future when they do have this one-time opportunity that comes their way. So it's interesting to have this conversation about postnups, prenups, all of that. So this has been quite enlightening. I've learned a ton, Marilyn, just in this short time frame.
Yeah.
Yeah. So, and the stories you have are incredible. You should write a book. Maybe you have. How can people get a hold of you, Marilyn, if they have more questions or want to perhaps work with you?
So I am at Blankroe, BLANKROME, in the New York office. You can go on the website. You'll see my email there. It's Marilyn Chinitz, CHINITZ.
We'll make sure all of that is in the show notes so everyone can reach out to you. And I appreciate you coming on today and sharing this wonderful information. Women, make sure you're taking action, reading all these legal documents, talking to an attorney, you're a financial advisor, you're a tax professional, all these different people to make sure you're really set up for success. So whatever you do after this podcast, make sure to take a little bit of action because that's how we're going to keep moving forward. And tune in next time as we have to keep talking about this shit.
Thank you.
Talk to you soon.
Information is for illustrative purposes only and does not constitute tax, investment, or legal advice. Always consult with a qualified investment, legal, or tax professional before taking any action.